Depending on the state you live in, that portion or portions of the house that you didn't pay for could, upon the death of one of your co-owners, legally transfer to their heirs, leaving you without a chance to purchase the remaining shares of your own home. More and more, in order for people to attain home ownership, they're jointly purchasing a home, also known as fractional ownership. But before you hop in on that good deal, you need to understand joint ownership property laws. More importantly, why I care about this is how we use life insurance to help solve some of these problems. We kind of focus on the joint property laws in the state of Maryland here, but these laws are very similar in the other 49 states. Categories of jointly owned property is usually subdivided in three ways: tenancy in common, joint tenancy, and tenancy by entirety. Now, tenancy in common is when all the owners own a specific share or piece of the property. These shares can be equal, but they can also be unequal, like a 75-25 or a 50-25-25. Regardless of the split, all the owners have undivided interest in the policy, meaning they all have rights to enjoy the use of the entire property. They do not have rights to survivorship, so if one of the owners passed away without willing that portion of the property to the other remaining owners, then that portion of the deceased owner's property would then pass directly to their estate, leaving the remaining owners no immediate legal right to purchase or keep that deceased owner's property share. So much like we would do in a business, we can codify those rights by purchasing a life insurance policy on each owner payable to each owner. This, in combination with the will directing those assets, allows the remaining owners to purchase, using the life insurance money, the portion of their property from the deceased owner's estate, giving proper consideration to that estate and then allowing the remaining owners to keep the property intact. Then there's joint tenancy, where all the owners have undivided interest in the property and rights to survivorship. The other owners automatically receive the deceased owner's share of property. No will needed. Catch with this is that joint tenancy has to usually be expressly stated in the deed. If joint tenancy is not expressly stated, many state courts have a presumption against joint tenancy, meaning if it wasn't expressly said, they automatically assume it was not and categorize it as a tenancy in common. We do often put in life insurance plans on all the owners because if the portion of the mortgage that the deceased owner was paying goes unpaid, obviously everybody loses all the property anyways. Then there's tenancy by entirety, kind of the most simple form of joint ownership, which is where if you're a married couple jointly owning the property, there's obviously undivided interest in the property and automatic rights of survivorship. Now again, even with spouses, life insurance is likely needed to help cover the cost of the mortgage. And if the spouse is divorced, the property automatically goes back to tenancy in common, bringing us right back to where we started.